Okay, I'll introduce our speakers now. Cali Kilabrew is an immigration attorney with Bend Immigration Group. She works with those seeking permanent legal status in the United States, seeking family reunification, individuals facing deportation proceedings, requesting asylum, and pursuing U.S. citizenship. Callie is fluent in Spanish and largely serves Central Oregon's Latino immigrant population. While her work focuses on navigating the federal immigration system in individual cases, Callie also cares deeply about making our local programs and policies more inclusive of our diverse communities. Before life as an immigration attorney, Callie served in the Peace Corps in Paraguay and was a social worker with farm workers in Hillsborough. Callie is a native Oregonian. She had a most interesting childhood living near John Day in a teepee and then in a one-room school log cabin. Callie has been in Bend since 2008. She has 2 school-age children and loves exploring Oregon rivers and mountain lakes with them. Michaela Guthrie, the other partner at Bend Immigration Group, earned her undergraduate degree from the University of Puget Sound and her law degree from Washington University. Micaela has dedicated her legal career to the practice of immigration law and has dealt with nearly all facets of immigration law. She has worked as the managing attorney of a nonprofit and as the assistant chief counsel for the Department of Homeland Security. Micaela has handled a wide variety of immigration cases, including business and family-based petitions, naturalization, removal hearings, and asylum. Micaela speaks Spanish and has worked extensively with Spanish-speaking clients. Micaela has made Bend her home for the past 9 years and enjoys spending time in the outdoors with her husband and 3 children. Please join me in welcoming Callie and Micaela.
Thanks, Karen. It's really nice to be here with you all and join the first Thursday. We just want to give you a snapshot of kind of what we do, who we serve, what are some of the issues that Oregon immigrants are facing right now, specifically Central Oregon immigrants, and some of these issues are new, some of them are not new, some of them have changed over the last 4 years, and then we'll try to kind of do a little look ahead and see what changes might be upcoming. But so yes, I'm an immigration attorney here at Bend Immigration Group with Micaela, and I'd say my experience as an immigration attorney is that a lot of times in Bend people say, oh, you're an immigration attorney, and in Bend, that's interesting. Are there immigrants in Bend? And honestly, over the last 5 years, I feel like I get that reaction surprisingly often. The reality is there's a sizable immigrant population in Central Oregon, Deschutes County, Jefferson County, Crick County, which is primarily the people that we serve. And that includes some naturalized citizens, people that are foreign-born nationals that have gone through the process and become U.S. citizens, many people with living without status in the U.S., and we have a lot of mixed status households where there's 1 or more people in the household that don't have lawful permanent status, but others do. And I think the statistics say 1 out of every 10 Oregonians is a foreign-born individual. 1 out of 9 people is a native-born American who has at least 1 immigrant parent. So it definitely the issue of immigration affects families considerably. And especially in COVID times, I think it's important to be aware of what the experience of our immigrant neighbors is in the middle of a pandemic. Many of our immigrant, in our immigrant community are essential workers working in housekeeping, hospitality, construction, and a lot of them don't have the luxury of working remotely, and they're navigating, in addition to the immigration hurdles, navigating educating children and without with language barriers and things like that. So I think first I'll turn it to Micaela to give you a snapshot of just the immigration system as it has existed for many years and the legal paths that we use to navigate people through the immigration system. So Micaela?
Thank you, Callie. So I think that how I'd like to start is just talking about what legal paths to immigration exist. So who can immigrate to the United States? There are three primary routes, and if you fall outside of one of these routes, chances are you're not going to really be able to immigrate to the United States. So we have a family-based route, an employment-based route, and a humanitarian-based route. So there's more than one humanitarian-based route, but those, as we will discuss further, are getting more and more difficult and challenging to successfully immigrate through. So we focus mainly on family-based cases, and so that's what I'm going to primarily focus on in giving an overview. So a United States citizen may apply for a spouse, a parent, a child, a sibling, or a married son and daughter or an adult son and daughter to immigrate to the United States. A lawful permanent resident has much fewer options, and a permanent resident can apply for a spouse, a child, or a son or a daughter, so long as that son or daughter is single. So these two different categories are broken down into two categories depending upon the closeness of the relationship. So a spouse, parent, or child of a United States sibling is an immediate relative, and there's no limit on how many immediate relatives can immigrate to the United States in any given year. Those remaining relationships are categorized as preference categories, and there is an upper ceiling and a lower floor determining how many individuals can immigrate through those relationships every single year. Employment-based immigration is also a preference category, and those different categories are broken down amongst priority workers, members of the professions holding advanced degrees or persons of exceptional ability, skilled workers, certain special immigrants, and employment creation categories. So a lot of times individuals want to know, what is the average length of the process? So for the most straightforward case, for example, of a US citizen in the United States who is applying for a spouse who is living overseas, I would say right now, that is, well, pre-COVID times, that was taking at least 2 years. Right now, we're at a standstill because the consulates have been closed in the vast majority of countries since mid-March, and only emergency appointments or very limited appointments are available. But pre-COVID times, when everything was running as smoothly as is possible to run in the immigration world, it was on average 2 years. For an individual who was fortunate enough to be able to do the process within the United States, that average time was roughly 6 to 8 months, but that was even increasing to roughly a year. So why is there such a delay? For individuals who are applying for somebody who's outside of the United States and they have to go through a process called Consular Processing, part of the delay is that U.S. Citizenship and Immigration Services, which is the agency responsible for adjudicating the I-130, the petition for alien relative that is used to start the process, that is taking a year to adjudicate. Once that has been approved and that case is then routed through the National Visa Center, there was a wait of at least 1 year before the foreign national spouse would be scheduled for an interview at the consulate. If that spouse needed a waiver and they had to apply outside of the United States, that can increase the wait time from 6 months to over a year. So it is not a very fast process, even in the most straightforward of cases. And for an individual to immigrate through a family member, what you need to prove are the required familial relationship, financial requirements, a medical exam, and the applicant for the visa needs to show that they are not inadmissible for any reasons. Now, a lot of times we hear about the really long wait that there is for somebody to immigrate to the United States, and a lot of times those are talking about like the preference categories. So as I mentioned before, there is a certain number of individuals who are allowed to immigrate through a preference category on a yearly basis. And that number, you have to take away people who are paroled into the United States and the number of immediate relatives who have been granted permanent residency. So some of these lines have wait times of well over 20 years. So for example, a permanent resident who wanted to start the process for an adult child who's over the 21 years of age, if you're from Mexico, there is a 21-year wait after your petition has been approved before you will even be considered eligible to attend an interview. And so that is an unreasonably long time to wait. These preference categories and the weights also apply to the employment-based, although a lot of those categories are actually current. So I also wanted to talk a little bit about refugees. So when we talk about individuals who can come into the United States, refugees are also one of the reasons. It's a humanitarian way to immigrate to the United States. The number of refugees who can come to the United States is determined on a yearly basis by the president after he or she consults with Congress, and that number is then further broken down by region. The number of refugees going to be admitted is at a low. It was capped by the president at 18,000 people. After a person has been admitted as a refugee, that person must apply for permanent residency 1 year after his or her admission. So if you think about a refugee, that is somebody whose status has been determined outside of the United States. We also have people who are seeking asylum, and that is what you seek for protection inside of the United States. And we'll talk more about asylum later as it is becoming increasingly difficult to receive. There is also a diversity visa. There are 55,000 annually, and these visas are issued to countries that have historically low rates of immigration. It is a computer-generated lottery that issues visas to individuals after they have submitted applications. So the rights of a lawful permanent resident. As a lawful permanent resident, you have the right to live and work freely in the United States. And after 5 years in permanent residency status, or 3 years in some cases, you can apply for US citizenship. And it's important to note that there's no limit on how many lawful permanent residents can naturalize in a given year. Now, apart from permanent residency options in the United States, there are also other ways for an individual to receive temporary permission to be in the United States. So we have deferred action, which the most common referred to deferred action now is the Deferred Action for Childhood Arrivals, or Daca. But there's also deferred action that victims of crime can receive and victims of domestic violence. There is also temporary protected status, which designates a certain country as needing its citizens need to remain in the United States because of either war, natural disasters, or other issues that are going on in the home country. And under the current administration, a lot of the countries have been undesignated, which is a really challenging situation when you're thinking about individuals who have resided in the United States for decades now being told you're going to no longer have permission to remain here. We also wanted to touch base on very quickly individuals who can possibly obtain residency status through removal proceedings. So for an individual who is placed into removal proceedings, there is a way that an immigration judge can cancel the removal of that individual and grant him or her permanent residency status. But in order to qualify for cancellation of removal, you need to show that you've been residing in the US for not less than 10 years, that you are a person of good moral character, that you have not been convicted of a disqualifying crime, and that your removal would result in either your parent, spouse, or child who's a permanent resident or a US citizen suffering exceptional and extremely unusual hardship if you're not allowed to remain in the United States. That is an incredibly high level of a standard to meet. And actually there has been some case law that has come out, which is making it even more difficult for individuals who are basing their relief on a medical condition a qualifying relative might have to be able to win that application. Also, just very briefly, there are a lot of barriers now to individuals being issued bond if they are taking it into custody. For example, a recent case came out saying that if an individual has suffered a conviction for a DUI, chances are they're not going to be released on bond because that is a de facto way to show that you are a danger to the community. So with that, I'm going to turn it back over to Callie, who is going to talk about new barriers that have been erected over the last 4 years So buckle up.
Thank you, Micaela. So as you can see, this immigration has never been easy. There's a number of barriers that are just inherent in the immigration law. And as Micaela mentioned, they're the family-based, employment-based, these different humanitarian routes that exist. There's one of the things that we see affecting our clients, if you've been here unlawfully for over a year, and if you depart the US, you're barred for 10 years. So even if you have a spouse of a US citizen and you have, children and you've lived here for many, many years, if you've entered unlawfully, then you would invariably, or not invariably, but normally you would have to return to the consulate to process your visa, then you would trigger a 10-year bar. If you've entered more than once since these laws came into effect in 1997, then if you entered, remained here unlawfully for over a year, and then departed, and then re-entered, then you're permanently barred. So even if we see people that have spouses who are U.S. citizens, many children that are U.S. citizens that can't immigrate in the traditional family-based route that exists. Even aside from the waiting periods and other issues that come into play. So in terms of the last 4 years, we've all heard about the wall that is going to be built is being built on the southern border. But really, over the last 4 years, what we've seen is practical changes in our work that have just added to the barriers that have really become kind of the invisible wall in a way. So, and which potentially have more lasting effects than the physical wall being built. So the first thing is kind of scaling back and termination of many of the humanitarian programs that existed before. Micaela mentioned temporary protected status for certain countries that are in the middle of armed conflict or environmental disasters, or have some civil have security concerns that are designated. Many of those countries have been undesignated, and there has been litigation about that, but we see a lot of people who have lived here for decades that are now in limbo because those countries many of the countries that are designated are being have been undesignated. And in terms of deferred action for childhood arrivals, Daca, I think most people have heard of Daca, but the program for people who came here as children, have studied, don't have serious criminal history that would disqualify them. And that program that started in 2012, Trump had indicated that he's going to terminate Daca. So he did issue guidance saying we're going to terminate Daca and let the existing Dacas expire. There was ensuing litigation that did stop. There was litigation that said, well, you do have to continue to accept the renewals of people that have had Daca before. But so the current state is sorry, I guess I'll read the questions at the end and try to answer the questions at the end. So basically, the current situation is, in terms of Daca, is that you had to be 15 to be able to apply under the initial program, and so people that had their initial Dacas already approved and continue to be eligible can submit renewal applications, but there aren't new applications being accepted. And another big change that came in 2018 was a new definition of the public charge test, so all family-based immigrants generally have to show that they're not going to be a public charge and rely on public assistance in the US. And generally, if you're a family-based, if you're going through the family-based immigration system, you have to have a sponsor who qualifies and show that they guarantee to the government that you won't rely on public assistance. And there's a new process that they went through regulations, they enacted new regulations to say that in addition to having a qualifying sponsor to guarantee that you won't rely on public assistance, you need to show that you will not rely on public assistance based on your own income, in your own educational credentials, and any prior use of food stamps or any housing vouchers or any public assistance can be used against you to deny permanent residency. So that rolled out, and very soon the concern when COVID came into, when we're in the times of COVID, and there was a significant concern that immigrants who may have children that use state-sponsored health care, or that there would be a tendency to not seek medical treatment for COVID, and there was litigation specifically around COVID. So the new public charge test, which many call as a wealth test for immigrants, is also tied up in litigation, but that was another barrier that was another layered barrier that was enacted through regulation. So unlike the Daca changes, which really came from just an administrative a memorandum, the public charge test was set out through regulations. So I think another change that we've seen over the last 4 years is heightened enforcement, and a significant departure from the enforcement priorities as they were set out before, as they were. I think in 2011 there was a significant. There were certain delineated priorities. People with DUIs, domestic violence, certain types of crimes were designated as enforcement priorities. And one of the things that happened by memo is basically saying that anybody in the U.S. without status is a priority, in directing immigration officers to initiate enforcement actions against anybody that's here without status. And where we've seen that change, we've seen that just changing the types of arrests that are generally made, whether they're directed at specific targets or collateral arrests of, and I'm not speaking specifically of here in Bend, but in the if an immigration officer is looking for an individual, they're more likely to arrest people that they come into contact with as in the process. And I think across the country there's been a higher percentage of people that are arrested without criminal history, and more large scale kind of worksite raids and things like that. So, and there's been significant changes in the asylum law as well. And I think I'll turn it over to Micaela to give a little snapshot of where those changes have been.
Thanks, Callie. So unfortunately, asylum has been being chipped away. The current administration is trying to limit not only the number of refugees who are allowed to resettle in the United States, but is trying to make it, in my opinion, virtually impossible for individuals who are already inside of the United States to claim asylum, or for individuals to feel that they can come to a port of entry and present a claim of asylum. So when we're talking about asylum, what does that mean? What exactly is a refugee? So an individual is a refugee if he or she is outside of the person's country of nationality, and if that person is unable or unwilling to return to that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. US law enshrines the protections of the International Refugee Convention, which came about as a response to the atrocities committed in World War II. So as I mentioned, there has been a steady and relentless chipping away of the protections for some of the most vulnerable of people. I have worked with people seeking asylum since I started my career in 2003. So this one is particularly hits close to home for me. So we are going to try to touch base on all of the different changes that have occurred. So many of these are caught up in litigation that it is difficult to say exactly what the status is of these proposed changes. And the fact that they're coming out as case decisions by the Attorney General, the fact that they're coming out, some as regulations, some as just memorandums, they all have different ways of being attacked in the court system. So starting in March of 2020, using the CDC orders regarding COVID, the southern border has been closed and the administration has been expelling individuals by the thousands, including asylum seekers, and has been denying access to counsel pretty much across the board. There were reports a few months ago about unaccompanied children being housed for lengthy periods of time in hotels, being denied access to counsel, and being removed to their home countries without being given the opportunity to present a claim of asylum to an immigration officer. In July of 2020, DHS and EOIR together, so the Department of Homeland Security and the Executive Office for Immigration Review, which houses the Board of Immigration Appeals and the Immigration Court, and they should be an independent judiciary body, but they're not because they're under the Department of Justice, the executive branch. They collaborated and came up with a proposed rule to exclude asylum seekers who have come from countries with a high rate of contagious disease or have traveled through such country, or if they show symptoms of a contagious disease. The justification for this policy is that these individuals pose a danger to the community and they are basically turned away at the border. Also this summer, there was a proposed transit ban, which was blocked, that would have prohibited asylum to someone who traveled through a third country before arriving in the United States. The vast majority of asylum seekers would have been prevented from seeking asylum based on this ban. We have also entered into a relatively new agreement with Honduras, El Salvador, and Guatemala, which allow for an individual to be removed from the United States and required to seek asylum in one of these countries if the applicant traveled through one of these countries on his or her way to the United States. It's imperative to note that these countries, El Salvador, Guatemala, and Honduras, have amongst the highest homicide rates in the world, and they are far from being safe places to seek refuge. In addition, so many individuals who are claiming asylum from these countries are claiming asylum based on either 18 or Mara Salvatrucha, which operate with impunity within those three countries. These countries also lack the capacity and the infrastructure to handle these claims. So not only has this portion of asylum been challenged by the administration by placing these insurmountable roadblocks for those who are inside of the United States, including many of our clients who entered 2, 3, 4, 5 years ago and are still awaiting adjudication of their asylum applications. We have internal changes as well. So not recently, 2 years ago now, the Attorney General issued Matter of AB, which is a precedential decision, and it gutted protection to victims of domestic violence and gang violence. So as I mentioned, I've been working with asylum seekers since 2003. So for this decision was particularly painful for me. When I was newly out of law school, I worked in El Paso, representing people who had just crossed in from Mexico. There, I had a client from Honduras who had suffered unspeakable acts of violence at the hands of her partner. We presented her case to the immigration at a time before the case law was clear that a victim of domestic violence could qualify for asylum, but we had to try. Her case was denied and we appealed. During the pendency of her appeal, and after the deportation officers read her file and released her on her own recognizance because of how horrific her abuse was, She moved to New York and her case went to the Board of Immigration Appeals. While her case was pending and due to countless other advocates who were also presenting these cases, the case law developed and grew, and soon we had a precedential decision that said that a victim of domestic violence could qualify for asylum. After almost a decade, my client was granted asylum in the United States. Now, that particular social group, which was developed by years and years of cases, generally would not qualify for protection. And the part about that that is particularly troubling is it was the Attorney General who has this power to certify a case to him or herself. So the Attorney General said, I don't agree with this decision. I'm going to certify it to myself, write a new decision gutting all the protections, and that is now your new law of the land. So that is a difficult pill to swallow. So there are proposed rules now that are going to have a non-exhaustive list of particular social groups, which are just flat out non-viable, which they have said, we just don't believe that these exist. These proposed rules are also trying to say that people who claim asylum for political opinion can't win unless their political opinion is to actively try to advocate a regime change. They also want to say that the harm you have to suffer is increasing. They're just making it more and more difficult for somebody to prove a claim for asylum. So not only are they making the cases harder to win, but they're making it harder for individuals who are within the United States to obtain certain things like an employment authorization document while they're waiting for an adjudication of their application. It used to be that if your application was pending for 150 days, you could file for employment authorization, and once you had 180 days with a pending case, you could work. And they would issue you a 2-year employment authorization card that you could keep renewing. And this is important because, for example, we have cases where people's cases where an application has been pending for 5 years now. So to think that people shouldn't be able to work while this is pending is a bit ridiculous. The new rule also says that if you enter the United States without permission and don't immediately present yourself at a port of entry, then you don't qualify for an employment authorization document either. There has been some pushback, and there are certain classes right now where if you register as a class member, you can say the old rules apply to me. There's also a federal suit pending regarding this, but it's down to this level that the administration is trying to take away protection for people who are fleeing horrific conditions. There was also recently, this just came out, I think yesterday or the day before, a new rule which they said, surprise, effective today, individuals who have attorneys, once they're in immigration court, you don't really need any preliminary matters. You're just going to jump straight to the final matter. So they are also eroding some due process, huge due process concerns for those who are seeking asylum and placed in the immigration court removal proceedings too. So with that, it's not, I'm sorry we don't have better news, but hopefully come 2021, we will have some of these rolled back. So that is what I am pinning my hopes on right now. And I can either turn it back over to Callie or we can go ahead and start answering some questions.
Callie, do you have anything else that you'd like to add?
I think there are a few other things. If maybe we can open it up to questions, and then if the questions dry up, we can talk about a few other things. I mean, I was going to mention just a few about the other barriers, like the travel ban and some other changes that have happened in terms of limiting access to agency decisions and or agency officials that make decisions in certain cases, and those are just procedural changes that actually on the ground have a significant effect. And this and Micaela mentioned the slowdown even before COVID. The slowdown and just grinding the legal immigration system to a halt was pretty substantial. But really looking ahead, I think we can talk about our kind of top picks if there are things that might change in the next 4 years. But as Micaela mentioned, it's a layered, what's happened over the last 4 years is very layered, and some of it's by memo and memorandum that can be reversed with a new memorandum. Some of it's by regulation, some of it's by the Attorney General decisions when they can refer a case to themselves and redecide the law. And much like especially the asylum laws that have been, 20 years in the making, can in some ways be kind of revamped with an Attorney General's decision. So looking ahead, I'm hopeful that there can be significant changes, but it's not going to happen overnight, and I think it's more likely to happen on a piecemeal basis. But why don't we open it up to questions and then see, and then we can chat some more if there's still time at the end.
We have a number of very involved questions in chat. So would you like to read them from chat, or would you like me to read those for you?
Sorry, can you remind me how to open the chat?
I can read them, Callie. I know how to do that.
Yeah, I can do it also. I'm fine.
Okay, Karen.
The first one is from Joan Lunsberg. How much of the tightening of immigration rules can be made less onerous by the new administration? Can current rules on temporary protected status be changed by the new administration? And you've addressed some of that, but go ahead and.
Yeah, so I think that there are certain things that the new administration can do relatively effortlessly. Like, for example, the Supreme Court has said the Trump's administration's termination of the Daca program was unlawful and that they should resume the program as a whole, to which USCIS and Acting Secretary Chad Wolf said, no, we're not going to listen to the Supreme Court because we know better than they do. So the President Biden can say, no, we're reverting back to the Deferred Action for Childhood Arrivals program as it was before they tried to stop it. So that's something that they can do. The temporary protected status designations, the Secretary of the Department of Homeland Security is in charge of reviewing those and determining whether or not it is warranted to grant an extension. So even though former Secretary Nielsen had said for a lot of countries, no, we shouldn't extend them, my understanding is that another secretary could come in and re-examine those determinations and reverse those if necessary. So there are certain things that are easier to do, like as we mentioned, a memorandum can be done away with by rescinding that memorandum or issuing another memorandum that supersedes all previously issued memorandum. An acting attorney general or an attorney general can come in and say, I'm withdrawing this decision that was issued by another attorney general. So that would revert back to case law as it stood beforehand. But things that have gone through the regulatory process will be a little bit more difficult to undo. Not impossible, but it's just going to take a few more steps.
Thank you.
There's another additional question from Kim Scott that some of it you've addressed, but Kim is also interested in finding out about the immigration camps at the border and the separation of families at the border, and also how much that can change with the new administration.
So yeah, again, with the MPP program, that can also be changed. I would need to double check to see how exactly that was promulgated, but that process is abhorrent. The separation of children and families, that is supposedly has stopped, but I know that I was talking to a colleague who says that as recently as last year, she heard about another child who was separated from a parent. The parent is being forced to remain in Mexico and the child is in custody of the Office of Refugee Resettlement in Florida. So it is still happening, but on a much lesser scale than it was before. Callie, do you have anything?
Yeah, I think some of the barriers that have, I think there's two different issues: the separation of families, and many of the children that have been separated from parents, they still have not. There are many of those that are still just unanswered, and that's going to be challenging for them to actually reunite some of those families. And the other thing, the metering and how you have to, the migrant protection protocols that has resulted in these kind of people need to wait in Mexico before they can enter the U.S. They have to be on a wait list in order to present themselves for asylum. This is aside from the COVID restrictions, but it's created such a backlog. I think it's going to take time for the courts to be able to. They can reverse the policy, but how they're going to handle the number of asylum seekers is a real challenge that I think it will take some time for them to figure out. But in terms of other things that might happen in short order, aside from the immigration, the camps at the border and the separation of children and families, we mentioned the full reinstatement of Daca, which could affect a lot of people that are here in the U.S. There's also an old law that allows people, even if they've entered unlawfully, to go through a family immigration system, even if they've entered the country unlawfully or otherwise violated their status and would otherwise be barred. They could renew that old law to say, now you can go through this process, or there's something called parole in place for specific individuals for humanitarian purposes. They can kind of create a legal fiction that they have been admitted to the U.S. to have a different path to regularize their status and adjust status in the U.S. There are different tools that they could change. It could have pretty broad sweeping effects if the administration chose to do those. But that's a broad wish list of what kinds of things an incoming administration. But I think that there's a lot that can be done on an administrative level, and many of the changes that have been rolled out over the last few years are in the middle of active litigation. So some of the outcomes and the impacts for families could change based on the positions in litigation that's going on.
We saw from the newspaper that Callie and Micaela were involved with the people who were detained on August 12th. So people wanted an update about that. Were either of the two people who were taken by the ICE authorities ever charged with a crime, and what happened to the two gentlemen?
So they were not charged with a crime. Remember, immigration is administrative law. It is not criminal law. So my understanding is that ICE said these individuals have criminal records, had committed crimes in the past, which led them to being targeted for the pickup. But after they were taken into ICE custody, they are not charged with an additional criminal charge there. I don't know the latest on what is happening with the individuals. I know that they were taken to Tacoma. One of them, I believe, was released on a bond, but I don't have any further information aside from that.
You have addressed a little bit of what we could ask of our representatives and senators, but I wanted to see if there was anything else that you have added. Callie mentioned reinstating Daca and renewing some of the other procedures around parole. Was there anything else that you can add?
That's a great question. I think there's a lot that can be done to allow local. I think it's really important to separate what's in our local control from what's in the federal control. And so if you in our community make sure people are safe going to school, and the people feel safe going to law enforcement, I think that limiting the information sharing between the local authorities and make sure information on a local level isn't shared with federal immigration for purposes of federal immigration enforcement. And I think that, and we have Oregon laws on the books that do make that's the Oregon sanctuary, what people call a sanctuary law, which is somewhat of a misnomer, but there's a lot that sheriff and police activities are here for the purpose of public safety and to have the trust of the local community. They need to not be asking about immigration status or for where somebody was born if it's not relevant to the investigation of a crime, which is what they're there to do. In terms of city and county policies, I think we want to make sure all of our counties all of our local policies are inclusive and accessible, and I think focusing on public safety and participation of the immigrant community in those policies is the most important thing.
And just one other thing regarding urging the representatives and senators to address and support. I remember a few years back having a meeting with an assistant for Senator Greg Walden, and coming from an immigrant advocacy position, and what was conveyed to us was that people who are anti-immigrant are much more vocal. So it's easier to complain about something that you don't like than to say, this is something I do like. And so I think it is really important that our elected officials, city, county, federal, state, all know I stand with immigrants, even if it's not something that's a negative, which people get much more emotionally charged about sometimes, to say, I'm glad we're a welcoming city. I'm glad Oregon has these laws on the book that prevent the sharing or prevent our state and local law enforcement from carrying out federal immigration officers' duties. I stand with immigrants. So I think that sometimes we forget that it is just as powerful to say what we do believe in as opposed to what we don't like.
Next question from Susan Cobb. I think you've addressed this pretty well, so I'm going to go ahead and move on to the next question because you've addressed what we can say and what could be rolled back. The next question is from Phil Chang on the treatment of immigrants to the U.S. depends so much on federal policy and law. Is there anything we could be watching at our local or state government levels that it could affect the treatment of immigrants, the sheriff or police activities, city or county policies? And I know you've touched on this a little bit. Is there anything else you would like to add?
Yeah, I think Callie did a great job answering all of these questions. And again, like, I think it is so important that we in Bend recognize that we are a welcoming city and that we celebrate diversity. We celebrate the immeasurable value that living in a diverse, vibrant community brings to us on a daily basis. And I will echo what Callie said when people said, oh, you're an immigration attorney. Well, what do you do in Bend? I mean, we do live in a diverse community, and I think that people just need to open their eyes and realize how diverse it really is. So I think that the library had an amazing welcoming week series of events. So participating in those and supporting those is also so important. Getting involved, volunteering, seeing what the Latino Community Association might need help with. Those are things we can do on an individual level. And I think Callie did touch really well on what else can be done on the city and county levels.
You addressed the diversity of the clients that you work with. One thing that I thought was really interesting in the preparatory talks with both Callie and Micaela was that it's not just the Latino community you're serving. There's actually people from around the world. Could you mention some of the countries that are needing your immigration assistance?
Yeah, of course. I think I personally have had clients from Latin American countries, from China, from Cambodia. I know the United Kingdom, Australia, New Zealand, and those are just the ones that I'm thinking of off the top of my head. Callie, what about you?
Oh, just in terms of recent, yeah, there's Russia, Spain, Portugal, Philippines. Yeah, there's, I mean, there's a number of, you know, we see people from all over. There's, I love. And that's what is interesting about this work is that, you know, we're working on a specific issue to get to a certain goal, but behind it is humans with interesting stories from interesting places, and we get to see that side of this community and every day, and it makes it very rewarding to go through navigating these immigration channels and getting to hear why people came here to the U.S. What brought them to pick up their life in their home country and move here, or if they ended up here in Bend, what parts of their home country they're going to in making their life here and making our community more diverse. So it's very rewarding. And yeah, I don't know what other countries I can think of off the top of my head, but it's really interesting.
The last couple of questions that we have so far also deal with asylum seekers. Do you anticipate the number of asylum seekers to rise to the huge numbers that were reached when thousands per day were requesting asylum in El Paso, in addition to others elsewhere?
You know, I don't see an end to people needing protection. So I can't anticipate, especially with COVID and travel restrictions, if there's going to be a huge surge in those numbers. But I understand that I do think that there's always going to be a steady flow of people who are going to be needing protection. And again, once the MPP is dismantled, then yes, what is going to happen to all the individuals who are right now being forced to remain in Mexico? That is a good question, and I don't know the answer to that.
People are asking about the title of your law office. Again, it's the Bend Immigration Group. And could you address how long you've been practicing here in Bend?
Yeah, so we started working together in January 2016, and both Micaela and I were practicing immigration law separately in Bend before that. So I've been here since 2008, Micaela and Micaela's. So we were before we joined up and started to work together.
The next question is about climate refugees. Have you had climate refugees?
I have not had a specific climate refugee, no.
And it looks like there's time for this one last question. What about access to education and support for families to participate in similar learning experiences and being involved in schools?
That is an excellent question. I'm wondering if this question specifically has to do with kind of COVID style learning, or just general access to education and support to families that are having to navigate this distance learning in COVID times. Or I know that let's see.
Sounds like Greg is saying both.
Both. Yeah. I know that the school district has, if somebody has issues with Wi-Fi accessibility, they've been trying to provide hotspots, but with the distancing need, especially with the current spike, I think it's really challenging for families. And I think Latino Community Association is an excellent organization that's trying to just provide, not necessarily in education. I think within the schools, I think there are fan advocates and different people trying to reach out to people that are struggling. I don't know of any organizations locally that are or what opportunities the public might have to support that. There's a huge need, is what I can say, and I just don't know if I have more resources to point people to.
One last question that we'll have time for. Do you work at all with people on guest worker visas, such as H-2Bs and all of the other different alphabet soup of visas that are available?
I used to in El Paso when I practiced business immigration, but we're not necessarily doing business immigration here at Bend Immigration Group, but for individuals who have entered on these visas and who might subsequently get married to a US citizen, then we do work with a variety of individuals who have entered on, as you said, Karen, the alphabet soup of all these different non-immigrant visas.
I'd like to thank both Callie and Micaela. There was a lot of work that you went into in preparing our conversation. It looks like there is actually one more question here. Without broadband in the rural areas, lots of folks are having hard times getting their children in education or being able to work from home or to know what is going on with COVID-19 in our state. So it sounds like that's more of a comment than a question, but a very good point. But we are almost at 1 o'clock. I want to respect your time because I know that you wedged yourselves into our talk here between everything else that you're doing. You're managing very complicated immigration cases. You're managing your own families. And I really appreciate your taking the time to speak with the League of Women Voters. This is the biggest attendance we've had this year. So I think that it was really, really appreciated. And you two both have an incredible wealth of information. If you ever have time to add one more thing and join the League of Women Voters, we would also love to have you as members. Thank you to Callie and Micaela.
Thank you all.
Thank you.
Thank you so much.
Yeah, we all